What is the procedure of obtaining bail in a criminal case in India? Let's try to understand this. Indian procedure of the entire criminal system is regulated by Code of Criminal Procedure, that is CrPC, and the provisions with regard to arrest, with regard to lodging of FIR, with regard to any complaint, with regard to bail, everything is given under CrPC. The sections dealing with bail are 436, 437, 438 and 439 in CrPC. 436 defines in what cases bail can be taken, in what cases bail cannot be taken. There is a schedule attached to the CrPC which determines all offences, and there is a chart given in schedule 1 which shows that what kind of offence is, which offence is bailable, which offence is non-bailable, which offence is triable by session court, which offence is triable by court of session, court of judicial magistrate first class, and all other things. In case of bail, what happens is if a police case has been registered against you in a bailable section, then the police is bound to give you the bail. In that event, what will happen is that police will arrest you technically and release you on furnishing a surety. Surety means one other person will stand as your surety. He'll fill up the documents, he'll fill up the bond, and whatever the court determines, he will fill up and say that 5,000, 10,000, whatever is the bail amount, that has to be filled up. And Form 45 is the format given in CrPC, which is to be followed. And equal surety of equal amount means another person will also be your surety. So this is the provision with regard to bailable offence. Surety is same in all offences, in all procedures. In the event if you are arrested by the police, then if it is a bailable section, the police will release. If it is a non-bailable section, in that event police will not release you and produce you before a court of a magistrate within 24 hours of your arrest, and there you can file your bail application. On the bail application, magistrate will hold the hearing and then order for either for your release or magistrate will say that no ground for bail is given made out, so bail is rejected. In that event, you can challenge the order of the magistrate or the session court before the higher courts. You can go to the session court or to the high court. If the bail order has been rejected by a court of magistrate of first class, then you can go to the session court. If the bail order has been rejected by a session court, then you can go to the high court. That is the law. So there you get bail on the basis of the FIR and the investigation being done by the police. Court will hear both the parties. They call the IO and they take the version of the IO, and then judicial mind is applied, and thereafter the bail order is passed. In the event of any case being registered, now let's understand the concept of anticipatory bail. Anticipatory bail is when your name has been put in any case where there is a provision, when there is a section of non-bailable section is imposed or included, then in that event you can file anticipatory bail. One remarkable thing is that anticipatory bail is always filed before the court of session or before the high court. So in that event, what will happen is that you will file a anticipatory bail before the court of session and say that I have been falsely implicated, and based on the FIR, based on the investigation carried out by the police, based on the version of the complainant, based on your defenses, court will consider and then pass an order that you should not be arrested. That is anticipatory bail. But in reality, what happens is that on paper, on technically, you are arrested and then released, because the most of the bail order says that you are entitled to be released in the event of your arrest, and surety amount is also prescribed by the court. So that way anticipatory bail is taken by the court of session, ordered by the court of session or by the high court or even by the Supreme Court. In the event your anticipatory bail has been rejected by the session court or by the high court, then you can go to the Supreme Court. In Supreme Court, any bail order is challenged under SLP. It is called SLP criminals, special leave petition, criminal. And after passing of the orders of the High Court, you have to approach the Supreme Court within 90 days, raise all the legal grounds, and based on that, the Supreme Court will consider an order for your anticipatory bail or release, whatever the case may be. So these are the broad provisions of bail. And bail means that you are being released on certain terms and conditions by the court, and you have to comply to those terms and conditions. In case you violate those terms and conditions, your bail bond is liable to be cancelled, your bail order is liable to be withdrawn, and it happens very often. So the conditions imposed by the courts, mostly in regular bail orders or in anticipatory bail orders, are different. Court sometimes says that you will not leave the district, you will not leave the police station, you will daily go to the IO, you will go to the police station to mark your attendance. And in some events, even the court says that you will not leave the state, or you will not go to the particular state, or you will not leave the country, you will surrender your passport. So all these terms and conditions may be imposed upon by the court while releasing you either on a regular bail or in anticipatory bail. So the provisions are prescribed under 436 of CrPC, 437, 438 and 439 of the CrPC. These are the broadly provisions of bail prescribed under the CrPC, which basically regulate all the conditions, all the eventualities of bail in India.